So hi everyone, and welcome to today's webinar all about oneNDA and standardization. And as Electra said, we've had a huge sign up list for this webinar, which is amazing to see. And it shows that what we're talking about today has really struck a chord with everybody. I'm Roisin Noonan. For those of you who don't know, I'm COO here at the Law Boutique and co-founder of the oneNDA initiative. For those of you who don't know, which you probably do given that you're at this webinar, but the oneNDA initiative is a community-led initiative which aims to create a standard form, completely open source NDA for everyone to use. And this was really born out of the frustration that we felt, and I'm sure a lot of you have felt, with the legal industry as a whole, where a lot of what we do is simply repetitive, really time consuming, and doesn't add masses of value, but at the same time is still necessary. So the oneNDA initiative is all about finding a better way of doing things, both for lawyers and for business more broadly. And we're also going to be talking about standardization more broadly today and the trend towards standardization within the industry. And if we get some time, we'll talk a little bit about the future of law more broadly as well. So I'll hand over to the panel for introductions. Sally, would you like to go first?
Of course, thank you. Thanks very much for having me today. My name is Sally Guyer. I'm Global CEO at World Commerce and Contracting, which is a non-profit association dedicated to the field of contract and commercial management. We have over 70,000 members around the world, so truly global, a very diverse membership, including a number of lawyers, but obviously those who work in procurement and contracting more broadly as well. So looking forward, standardization is something that we've been at the forefront of for many years. And I'm very excited to be part of this oneNDA initiative and talking to the group today.
Thanks, Sally. Alex?
Hi there, I'm Alex Herrity. At the moment, I'm Senior Director for Legal at North Europe and Nordics in Adidas. But typically my day-to-day role is as kind of legal operations within Adidas. So I'm kind of coming at it at the moment from two hats, which is really cool, a little different opportunity for me. But in terms of the oneNDA, yeah, NDAs have been a bit of a pain in my neck for the last kind of 12 months, specifically my legal ops role, but much longer in my legal kind of counsel position. So I'm really excited to kind of look at this and look at standardization in a kind of, you know, we're working with so many different people and trying to tackle this topic, which can feel like a really small topic, but actually there's so many parts to it. And I think it will be a really nice kind of start to a longer conversation in the future about standardization of documents in the future. So I'm really excited.
Absolutely, awesome. Thanks, Alex. Ollie?
Hello, everyone. My name's Ollie Buxton. I'm a lawyer at UBS Investment Bank in London, and I also run a blog called The Jolly Contrarian, where I spend quite a lot of time talking about process and you know the difficulties of legal things, and that's how I got talking to Electra and the team about this sort of thing. So I'm have had 30 years of dealing with some of the ugliest documents in the legal universe in investment banking, and in particular in derivatives. And my thing is just about absolutely simplifying wherever one can simplify things, taking unnecessary complexity and in terms of processes and waste and technology out of things as well. And so when the opportunity came up for this, and I think exactly as Alex said before, the NDA is quite an easy case. It's an interesting small thing that everyone understands. But if we can get this to work, then what else can we do? Where can we go from here? It just establishes a really interesting beachhead. So I think this is a fabulous initiative. I think Roisin and Electra have done a fantastic job of getting this group of people together. And so it's incumbent on all of us now to make this work.
Oh, good. Thanks, Ollie. Electra?
Hi everyone, I'm Electra. I'm the founder and CEO of the Law Boutique, and I'm also the co-founder of the oneNDA initiative. And just want to give a bit of background on why we started this. So basically we spent the last year, 2020, growing really rapidly as a team and really streamlining our offering. And so at the end of the year, it was really important for us to understand what it is that we'd done over the year. So we looked at the statistics of the types of contracts that we'd reviewed, because we offer a legal managed service, so we take away the heavy lifting from the teams that we work with and help them optimize the way that they work. So we looked at those and we found out that 63% of all the agreements that we looked at were NDAs. And that only accounted to about 7% of our revenue. And we said, what a ridiculous statistic. We can't call ourselves a legal optimization company and not do something about this. So I kind of went on LinkedIn and started ranting. And I got some other fellow NDA haters that were supportive. And from there, the oneNDA initiative started. So the way it started was a bit like a nutty professor where you go, oh my God, this is exactly what we need to do. We need to standardize the NDA. So I spent a weekend building a Squarespace website, and I decided to test it out. And I said, let's put this out. Let's put this out, and let's try and get 100 people to sign up by the 1st of March. And this was the 16th of Feb. So I called Roisin. I was like, I've got this amazing idea. She's like, okay, what is it? So we decided to just kick it off, and we actually achieved the 100 members in 12 hours from launch, which is, I think, evidence that we really struck a chord with the NDA. It's quite a low-hanging fruit for standardization. And then by the 1st of March, we had 331 sign-ups from some amazing organizations, global organizations, who are really interested in this initiative, but also law firms and legal consultants and legal tech vendors and freelancers and business owners, CFOs going, yeah, this is insane. Let's just standardize the NDA. So today, I think we've got about 600 applications or something close to 600, and we've already kicked off the project with our steering committee. So the way it's going to work is that we've got a subset of the in-house lawyers that have signed up and a subset of the law firms that have signed up, and we've built a steering committee. And there's also a small group in there like Sally of research partners who are providing us with really important insights into, how is this working? What litigation have we had on NDAs? What should an ideal NDA look like, etc. And Sally, you can talk about that in a minute as well. So yeah, we're taking a very design-led approach to the NDA creation, and it's really, really exciting. So
excited. Thanks for that lecture. Ollie's video has dropped out. It may be a brief dropout, but otherwise he might be a bit of a silent partner here. Well, not silent, but invisible. Let's see. Cool. All right. That was really, really helpful. Thanks, Electra. So it would be good. We've got a bit of a cross section here of different players in the industry. You've got Alex, who's on the Adidas side. You've got Ollie, who's also in-house, but on the corporate investment bank side. And Sally, obviously, you're from a standards organization. So it'd be good to hear about why this is so important to each of your respective organizations. And Sally, it'd be good to start with you because you've been on the standardization journey for a longer time than this initiative. Oh, Ollie's back. Ta-da.
There we go. Well, so as you rightly say, Roisin, standards, this is something we've been talking about for some time. And, a little anecdote to describe the genesis of a lot of the work on standards actually is generated by the legal community, and particularly in-house legal community. And back when I first started with what we were then IACCM, now World CC, we were contacted by the GCs of 3 global telecommunications organizations who came to us and said, help us, because we are so frustrated with entering into negotiations, always taking extreme positions and always landing roughly in the same place. So we start out here, we always end up here. Why can't we start here? If that's where we always end up, why can't we start here? So we embarked on a journey with these 3 organizations, and that again morphed into many, many organizations because they were coming at this from a sell side perspective. One of the things that's so important as far as our community is concerned is that we are representative of both buy side and sell side. And of course, it's critical that you're embracing all of the stakeholders in the process when you're undertaking these kind of initiatives. And it was very fascinating, and it's been a long, long journey, and it would take more than the 45 minutes that we have today to talk about all of that. But ostensibly, the important point here is that there is an absolute desire for standardization. There's a complete recognition of the importance of standards, the impact that standards can have on both efficiency and effectiveness within organizations, on fairness and balance, on the nature of relationships as well. So as you have talked about, this is an initiative focused on non-disclosure agreements. There is so much more to be done in the standards space. We are just really focused on supporting organizations to create that body of standards. The challenge and the barriers, and I think it's really important to talk about those as well, is the artisanal approach that's taken often by the legal community. And there's a fear around standards. And when we approached thousands of organizations about the contracting principles, which we've now developed, there's a sense of reticence of adopting those principles because organizations want to have their own positional approach. So we know that there are barriers that still need to be overcome, but certainly the push for standards now is stronger than it's really ever been before. There are lots of reasons behind that, which I'm sure we can go into in more detail later.
Definitely. Thank you for that, Sally. I think there's lots to unpack there, particularly on the buy-in point, which I think Electra would be great to talk to you about that in a minute. But another point that you raised is about efficiency and waste. And Ollie, I know you've written a lot about that in the Jolly Contrarian, so it'd be good to hear about your perspective on how wasteful we are or not as lawyers.
Yeah, so it's a really interesting one, and in the investment banking world, you spend a lot of time onboarding clients, and the general trend has been to focus on cost and reducing costs. And how do you reduce costs? Two ways: you get cheaper units to do it, and you get cheap. You know, when I say units, I mean people. You get cheaper people, and you have people in smaller silos with less areas of competence. They are juniorized, they're often offshored, and so you create additional overheads and additional management structure around other things as a compensation for the difficult job of having negotiations done. Now it seems to me that we got that proposition somewhat wrong. And if the answer is that, look, the agreement isn't as complicated as all that, then rather than leaving it as it is and making cheaper people do it and automating it, the better thing to do is to look very hard at what the agreement is and how can it be simplified. How can you take optionality out of it? How can you take confusion out of it? How can you take the ability to wangle and argue and argue the toss out of it and make this thing as standardized as possible? So and it seems to me that all other things being equal, the best thing to do is take stuff away rather than add stuff and add process. And I think and again, we have a whole lot of lawyers here, and unfortunately we are sometimes the problem, not in the solution to this. And some of it's psychological, some of it's I've got a job to do, I've got to be seen to be making a difference and having an effect here. And how do I do that? Well, by adding a little for the avoidance of doubt, or changing this or changing that. And I think this is the challenge to all of the people in this working group, and particularly the private practice lawyers who are the drafting experts, is we have to resist the temptation to perfection, resist the temptation to infinite particularity of things. And remember, we are trying to design a product ideally for business people to use without lawyers. Look, I've got a simple thing I need to achieve here. I want to get on to negotiating a deal. I've got some confidential stuff that I don't want to get out. I just need quickly to have, are we good? Are we simpatico on this? So we can move on to the more interesting thing. And as Alex has said and Sally said, once you have this idea, then what else can you take that towards? This is just a great place to move on. But the first thing is, let's see if we can do it on a really simple, a simple platform.
Definitely, like couldn't agree more. I mean, sounds like it shouldn't be that difficult, but we'll see. Alex, it'd be great to hear from you on all of this. I know obviously it's great that Adidas has its own legal ops function. That's kind of, miles ahead of a lot of organizations. And I know that you're really interested in legal tech, and I see a lot of what you're posting on LinkedIn about that sort of stuff. It'd be good to hear about, what the impact of standardization, particularly oneNDA, would have for you.
Yeah, that's cool. So I think from my point of view, something like this really strikes at the heart of what a lot of legal teams, in-house legal teams at least, really want to do. And most good, good legal in-house legal teams are saying they don't want to be a barrier to business. And I think NDAs are a barrier to business. They're an unnecessary friction that doesn't paint legal in the best light, I think. And for what it drives and for the benefits that it brings, it feels like a really kind of unfair balance, and it's just not being nailed correctly. And the thing that really intrigued me about this topic was it was almost a different kind of option to look at something like this. So from a legal ops perspective, most of the time, a bit like Ollie's saying, you're looking at just kind of how do you find the cheapest, fastest way to do this, and it's usually by finding a tech solution, or it's by getting outsourcing it to the cheapest person to do it, or finding ways to kind of make little improvements, but fundamentally you're doing it in the same way. You're just drafting a document where you might make a few changes. And I think this is just a totally different paradigm where it's kind of, we're not looking at it from that lens anymore. We're basically saying we can all agree to this and we can all work from this centralized, standardized point of view. And for me, that was just such a, you see it in other industries, but it was such a kind of novel way of looking at this concept that didn't feel intuitive to most lawyers or to most legal ops professionals. You feel like, I've got this problem and I've got these levers to solve it. And actually this one around standardization was kind of dusty and in the corner, and you never really thought about it in that same way. And you might think about standardization in the terms of making the document slightly more kind of, usable, but this thing about everything into the same concept is really, really super interesting. And I think that big friction point is the thing. It's removing friction in an area that just doesn't need friction. It needs, it's like, it's a simpatico thing that Ollie's saying. Do we get each other? We get what we're doing here, and we're both bought into this same concept. Let's move on and let's talk business. And that's what all corporates, but I think every legal department wants to be able to empower their business to do. So it's taking that strain away from us. And
it's almost like an extra step. Everybody has their standard form internally. It's just an extension of that, and people still sort of balk a bit at this concept of standardization more broadly in a cross industry sense, but it's like everybody has a standard form, so it's kind of just an extension. Electra, there's a lot of points that I wanted to pick up with you that we've heard, but buy-in, what it means more broadly for the industry. Go ahead.
Well, I think that lawyers need to start looking at software developers and copying the way that they work. Because the only reason the internet works and the only reason software works generally is because of this idea of standardization and interoperability. And that does not exist in the contractual world. What we do as lawyers is exactly, Sally, I keep copying what you say, and Ollie, I keep copying what you say as well. So forgive me, I'm going to sound like a copycat. So what Sally said earlier is that we take this very artisanal approach to law. Oh, this is my preference. I like to construct my wording like this. Yes, but you're actually just saying the same thing that guy said in different words. What's the point of you both expressing yourself? This is not an artistic competition of expression. We're trying to do a job. We're trying to get something done. We're trying to give effect to a legal document, and you're worrying about whether your stylistic preference is this or that. No one cares, especially when it comes to the NDA. So let's just bin that and let's just agree on a standard and move on. And if you look at the software world, that's what they've done. And I'm going to sound probably like an idiot talking about the internet and trying to explain it because I don't actually understand it fully. But what I do understand is that they work, the way it works is through the exchange of packages of data that all have the same structure. So you've got a header that tells you what that package data is, and then you've got a payload, which is the actual code. If you think of a contract in the same way, you've got the headline clauses, and then you've got the code underneath, which is the legal language that builds out the contract. So it's like you're stacking modules of data to create a contract. And a lot of what the oneNDA is trying to achieve is also a change in the way that we perceive contracts. It's not just a load of words that we have full flexibility in writing out in order to have an X effect. It's now, let's think about standards and let's start stacking those standards to achieve what we want to achieve. And if we're all starting from the same starting point, then it's just so much more scalable. And scalability means efficiency, speed, saving time, saving money, saving ourselves from the drudgery of NDAs and other boring stuff. Like, how many times have you read a severance clause, for example, and how different was it to the other severance clause that you read? Not at all. But what you're doing is fear checking. Oh, have they snuck anything in? Why? That's not necessary for us to be effective in our roles. So I think it's rethinking the whole structure of contracts. And I think, to your point, Alex, throwing tech at it isn't going to solve the problem. Ollie, I'm going to copy something that you said now. Ollie said once, we've taken a manual process, which is a written document, a hard copy document, and we've put it in Word. So we've now added technology to a manual process. So a 10-page contract can now very quickly become a 150-page contract. That's not solving the problem. You're just making it quicker to make the problem worse, because the process in the first place was not correct. So sometimes when I see people on LinkedIn going, tech vendors need to start thinking about the fact that we're working in Word, so any solution that they provide to us needs to be compatible with Word. No, that's just a resistance from you to think a bit more broadly about what you could achieve. You're not thinking about what you're trying to achieve with the contract. You're thinking about the tool that you're using to achieve the contract, and you're trying to solve for the tool and not for the outcome that you're trying to get the tool to achieve. So, yeah.
That's great. Thank you for that. That was really, really good. I should say, actually, please pop questions in the Q&A as we're going along, because I want to leave a decent amount of time for questions, because I think there'll be a lot coming out of this.
Yeah.
I think something that everybody has touched on is about mindset. And I think as lawyers, common law is essentially born out of the protection of private property rights. And I think lawyers have become even proprietary over the words in which they use. So how much of this is about mindset, and how will we go about shifting that? Sally, it'd be great to hear from you.
So you can, I came off mute because I was like desperate. I've got so much to say. But, it's so much. Electra, what you've talked about is absolutely right. Yet it requires such a monumental mindset shift in the way that lawyers work, and the way that contract drafters work, and the way that lawyers are taught as well. Frankly, the underlying business model of the legal profession acts as a barrier to significant change in this space. But, I think actually Ollie will probably be very interested in this. About 3 years ago, we did an analysis of master services agreements in the financial services sector. We had about 120 agreements, I think, roughly along those lines, all ostensibly on the surface different. All were using different language, as we've talked about, this sort of artisanal, proprietary approach. But because of the sort of leading edge technology now, AI, NLP technology, you can do analysis of these terms and conditions. And the output of that particular study confirmed that over 90% of the content of those agreements were the same. They were just written differently, so they looked different. And of course, I can't remember who it was who said, there's an element of protectionism, and well, this is my job. This is what I do. And the shift to a world of standards, which will happen, by the way, whether we want it to, whether we act against it, or we help to proliferate the change, it is going to happen because there is just an urgency and a necessity around changing the way we contract now. The pandemic has thrown this all into stark relief as well. The wasted time, the inefficiency that exists for organizations in the way they do contracting. So there is an enormous shift to take place, and it transcends the entire industry.
Great, sounds exciting.
Go on, I think there's another problem here, and I think, again, Ollie, you might want to say a bit more about this, but there's this idea that legal language is the intellectual property of the drafter, when it's not. There's no real intellectual property value. There's no, it's just language that does a job. It's a utility. Yet law firms and even in-house lawyers view it as their own intellectual property. You've got really big businesses built on legal language and they sell it as though it's IP. They license it out. Whereas actually, if we started to standardize, then the other piece is to open source. Because you've standardized it, cool, now no one owns it, let's all use it, and then let's all start from the same position.
Yeah, I completely agree with that, Electra. And it's, you know, there's a sort of quite a large sort of generational thing. You know, this is part of how the internet's developed, and we've got two strands, which is the internet is in favor of freedom and mashups and reusing stuff and no propriety and you know, freedom of creation. But then the commercial world has gone down this rabbit hole that everything's got a value, everything is mine, everything has to be you know, protected at all costs. And you know, it's quite ironic in the context of a non-disclosure agreement that we're talking about the proprietary nature of the text of the non-disclosure agreement. But it's like, you know, look, you know, in any contract, and Lord only knows, financial services contracts are long, right, Sally? They go on and on and on. 90% of that is boilerplate. It does the same stuff, and nobody gets any value out of it. You know, it might make us, you know, it might give me a sense of professional satisfaction that I alone can understand a 320-page trust deed, indenture for a, you know, a CDO or something like that. But there's no real value in it, and these things don't normally get litigated in a final world as well. So actually, the more we can standardize this, have it out there as this open source thing that people can just use, you know, there's going to be plenty of room and work for lawyers to do the interesting structuring of real deals rather than retreading, you know, confi agreements over and over again.
It's a really important point as well, that point about the usability of agreements. You know, our research shows that over 90% of business users don't understand contracts, which is why contracts go in a drawer. Typically, that's the classic, you know, well, let's put it in a drawer now. Because the people who draft and negotiate agreements are very rarely the people who are responsible for the delivery and that operational management capability post-award. So we draft contracts not for users, but for law courts. And that is not helpful either. So this whole shift, and there's a huge movement around design and simplification now. And I'm very excited about that too, because we simply have to start as a legal community designing products, because a contract is a product, arguably, for the users of those products.
Definitely.
And that's such a good, I've just got to jump in on that, designing for courts, because this is my thing at the moment, absolute bee in the bonnet. You know, that you often hear people say, well, you know, like lawyers, we're here, we're drafting for a judge. And it's like, no, that's like surrendering before kickoff. You are designing and drafting so that this thing never gets anywhere near a judge. It's so clear that both sides of the party completely understand what's going on. It's like, why would I go and take this to a judge? Because I'll tell you that the judge isn't going to understand the commercial contract. So you know, again, this is about putting something in the hands of business guys who, you know, who go, I understand the deal. That's it. We're done. We can move on to the important stuff.
Absolutely. I was going to ask you, Alex, to jump in on that as well, because I know you're really interested in legal design. It'd be good to hear your perspective.
Yeah. I mean, from my side, I think the original question was around kind of the whole mindset stuff.
Yeah.
And I think, you know, clarity has obviously got a huge part of that. And I think the funny thing is that I think the legal profession is a very anecdotal profession. You know, we don't have a great set of source data to rely on. So it's really fantastic to have Sally on the conversation, just dropping in these facts and these studies that have really kind of driven some of this stuff. And I think, you know, I'm very sure that people have thought about standardization in certain areas before, and it kind of falls away because people just go, you know, I don't think that'll work, or the kind of the naysayers can have their way and weigh in. But actually, you know, some of this statistical stuff that's going to support some of the thinking behind this, I think will be powerful in the change mindset part of all of this. Not to say that it'll completely steamroll everything. Everyone will still have some resistance and there'll be things to do. But I think from our point of view, you know, I really like a lot of the legal ops things where we remove assumptions and these kind of, you know, I like to see people's working. You know, a lot of this is just inherently gut feel on things. And it's like, when you really force people to show their working on these decisions and really show where they're coming from, that's where you can really get into the nuts and bolts of where they're coming from. It's totally unfounded. It's not based in data. It's not based in reality, really. It's based in their assumptions and their experience, which they place a huge amount of value on because the legal profession is a huge experience game. But it's a bit of a fallacy on some of this stuff. It isn't true experience. You feel like that's the way that it should be. So I'm really interested to see how that kind of side of things is going to play out. And when we're kind of trying to land this, we're kind of jumping ahead of ourselves. It'll be really interesting to see how the feedback from the committees and the feedback from everyone to say, how do you make this an impactful thing for lawyers and for business, and really show them that, you know, we're not taking our hands off the wheel here and being totally crazy. We're actually doing something that makes a hell of a lot of sense. And here's the data that supports it. Oh, and by the way, here's a really nice document that you can understand rather than this horrible thing that we used to produce for you all the time. So I just think there's a really great opportunity here to turn some of these kind of conceptions on their head and deliver a product at the end of it, which is actually fit for purpose, really easy to understand, and is kind of a win for everybody. But it will need some change management regardless, because even the nicest product doesn't get everybody over the line.
No, absolutely. And well, go ahead, Electra.
Agreed. I think that this isn't an initiative of standardization. This is a change management program at an industry level. And I think that if we can start with the NDA, and there's a question here from Andrew, and Andrew and I had a conversation ages ago about standardization. And Andrew's question here is: standardization of complicated contracts already has a precedent in the construction industry. Is the NDA the right place to start, or should we be looking to build an agreed legal dictionary for use in all contracts? I think yes, we should. We should end up with a library of open source clauses that we all use to mix and match and build a contract based on standardized wording. If 90%, Sally, of contracts are standard wording, the same concepts but in different words, then that sounds completely wasteful to me. I think if we can just start with standard boilerplate clauses that we've all agreed to, then we can start using lawyers to draft the tricky bits, the bits that really need a lawyer, right? Because you don't need a lawyer to draft you a notice as a clause. But I think that if we throw that at the legal community right now and go, right, guys, let's all agree to this library of clauses, I think it's just too much. So I think we should start with the low-hanging fruit first, because this is a change management program. And a lot of it is psychology-based and how we derive our value as lawyers. Lots of people identify at an intrinsic level with the fact that they are lawyers, and that's absolutely fine, and we need to respect that. So when we're going into the community and saying, guys, let's change the way that we work, we can't just be throwing the kitchen sink at it from day one. And this is why I think perhaps other standardization initiatives haven't been entirely successful. It's because there needs to be buy-in. There needs to be stakeholder buy-in at the outset. We need to do this as a community. We can't just have one person go, here's a library, let's all agree. Here's an NDA, let's all agree. That's not gonna work, because every lawyer has their own opinion. That's how we're trained to think. That's how we're rewarded and incentivized throughout our career from day one when we go to university. So we need to take all that into consideration. This is not just a practical matter. This is a very human matter. And taking a human-centric approach to this is imperative.
And I think that point about opinion, though, is a really important one, Electra, because there's less and less room for opinion now. There was a fabulous quote from a GC that we work with that we repeat over and over again. But this GC said, my CEO used to value my opinion. Now she just wants facts. And that's, and it's true. And it's a really, really important point. And as Alex was talking about, it's absolutely imperative that the change is underpinned by data, because that's the way that you bring people on board, as well as the stakeholder engagement. I mean, I was interested to see in the chat, there's a comment from Peter talking about, huge challenge he faces as a lot of lawyers resist change with every inch of their being. I feel your pain, Peter.
I mean, look, but that's how we are trained, right? The doctrine of precedent is do whatever you've done before. Don't try anything new. No one got fired for for buying IBM, and it's a big block, I think, to come over. And I think, Peter, you're absolutely right to make it. And so one of the challenges that we've all got is to think about, okay, what are the sort of behavioral psychology aspects of this? How do we hack the legal mindset to get people across the line? Because, and there was a question in there also about, when do we start with a blank page and this sort of stuff. The moment you put a document in front of 5 lawyers, let alone 100 or however many electors manage to get signed up, that thing's going to turn into a gorgon. And unless we have got a really good handle on, look, this has got to be straightforward. This can't be for the lawyers. This is for the business people. And that's the real challenge of this process.
I was just going to quickly add, I'm sure there's another question, but I think the interesting thing about other standardization projects for one of the questions around construction is, I don't know the exact detail, but I bet the decision around that wasn't driven by the lawyers being involved. It was the industry. And we're talking here about standardization of NDAs. Business doesn't own NDAs. There's no one area, there's no one industry. It's cross business. So this is a real example and a real opportunity for legal to disrupt legal for itself and not be reactive. And I think that's such a really cool thing to be like, we're not just having this dictated to us to kind of, some construction guys have said, get your heads together, guys, figure this out. This is us saying, we're going to make our lives better. We're going to make ourselves an added value prospect for our businesses. And we're going to create something standardized here and move things forward rather than being driven by business and business needs all the time. We can really take the lead on this one and deliver something quite impressive.
And that's a really good point, Alex, that, there are discussions at an industry level going on all over the world at the moment about standards. The aerospace and defense industry are having huge discussions at the moment. The oil and gas sector is also, and the oil and gas sector has a precedent around health and safety, and they are looking as a community to see how they can replicate what they've done around health and safety at an industry level in the field of contracting. It makes perfect sense. So as lawyers, we absolutely need to be aware of those conversations. We need to get ourselves involved in those conversations, but we need to bring positivity, if you like, to those conversations as well, rather than I'm not sure you should be doing that approach, which obviously shuts the door on involvement very often.
So I know one more thought about the construction contracts too, which is a really interesting one. So I've been where the construction contract regime, and actually ISDA in my world, which is a derivative thing, is different, is yes, that's an industry standard, but that has been brought together by one part of the contracting universe. Because I can tell you for sure, and I've got the evidence of it behind me, that the consumers don't get any say in that construction contract, and they are weighted unbelievably against the consumers, who is just the dead weight that doesn't get any say. And we almost came to litigation with that extension there as a result. And so why are we different here is because Roisin and Electra have done this fantastic job of getting people from across the piece. We've got industry, we've got Alex, we've got financial services, there's Coke, there's Google, there's all sorts of people from all different walks of life, and they're all saying the same thing. So this one, I feel, has got a chance to be a standard, and it is because it becomes okay. And so here's another challenge to the people out there that are listening to this. This works only if you guys use this. Because if everybody starts to use it, if it's known that Google's doing this and Adidas is doing this and Coca-Cola Ambertil is using this and Barclays and UBS are using this, then what you'll find is the behavior of lawyers will be, well, I'm doing that because everyone else does that. You know what I mean? Lawyers love what everyone does. So this is the thing where we've got to be the movement across the piece to go, this is the right way to go, and I think the lawyers will follow.
Definitely. I have one last question for you all before we ask some of the questions in the chat, although most of them have been answered. So what's the end game for all of this, if you could take a punt on that? I think a lot of the pushback that I've heard thus far is that this will reduce jobs. This will kind of like eliminate jobs for junior lawyers because they're not cutting their teeth on NDAs or more standard documentation. Do you see that happening? Where do you see the end game for this whole thing? Electra.
I think that's just such a lame thing to think. Which paralegal or junior lawyer goes in fresh out of uni, excited, oh, can't wait to review this NDA? Zero trainee lawyers say that. Maybe lawyers should start being trained on how to construct, how to structure information. That's what we do as lawyers. We structure information, and that information needs to be understandable by business. If 90% of business stakeholders don't understand contracts, then we're not doing our job. It's just simple, because that contract is really not going to go to the judge, very, very rarely. So if you're not serving the 99% of your audience, then what are you doing? You're future-proofing, but you're not adding value. You're just risk mitigating. Whereas if you created a really clear contract that the business understood, and you had structures behind how to do that, maybe we should get some UX training. Maybe we should get some training from software developers and designers as to how to structure a document so that the audience can understand it. And I think that's a much more intellectually stimulating and value add thing to learn than how to review whether the definition of confidentiality is good enough.
Definitely. Alex, we've got 3 minutes left, so a minute each.
Okay, super quick. Yeah, I mean, from my side, I just kind of reject that hypothesis. I'm just kind of not interested in it at all. Maybe there's a minor bit of consideration from law firms that are maybe cashing in on some of these selling NDAs to people. I don't care about that. I'm on the wrong side of the fence. So from my point of view, yeah, there's plenty of other work that's more relevant, that's more interesting. And if you go back to the classic kind of legal ops thing, the whole triangle of work and where people should be focusing their attention, there's a hell of a lot more stuff up the pyramid, which is more interesting. You can get more junior lawyers involved to learn real things rather than focusing on NDAs. That's my short answer.
Definitely. Sally?
So one of my favorite quotes came from an academic in the US, and it's, the future of the horse was not, and I haven't got the image, was not an automated horse. It was a bicycle. So, the message here is we've got to stop being wedded to the past. We have to think completely differently about the future. Deloitte recently commissioned us to undertake a survey, and that survey revealed that 66% of organizations are viewing digitization of the contracting process as an urgent priority. That is we can't digitize what's old. It's going to require a whole new way of thinking.
Great. Ollie?
So in the entire history of innovation from the wheel, there's never been an innovation which has put people long-term out of work. And I've done a lot of simplification and cutting out of manual work in the institutions that I've worked at, and inevitably every time what it's done is increased volumes. It's enabled people to do trades that they couldn't do before because the legal team was all tied up doing confies the whole time and they didn't do it. So I share the panel's view. I don't have any nervousness that, oh my word, I'm going to be out of work here. I just look forward to being able to do some cool stuff rather than the drudgery that I have to do at the moment.
Definitely. All right. Well, thank you so much, guys. I know we didn't get to answer all your questions. We kind of did, but any others, just drop me, Electra, an email, or anybody else on the panel. And yeah, see you all again soon. Thank you so much, panel. That was amazing.
Thank you. That went really quickly.
See you all soon.
Thank you. Bye-bye.
Thank you.